Yes.
Yes, Your Lordships. I seek court indulgence in mentioning hearing item number 4 and 6 on behalf of Miss Mary.
Miss Mary.
Yes, my lord.
What happened to her?
She's having some personal difficulties.
Personal difficulties?
Yes, my lord.
Okay. Right. On the prayer for adjournment made by on behalf of Mrs. Mary L. Kiangte, learned additional PP, list the matter after?
After 1 week, my lord.
After a week.
Obliged.
For motion, item number 1.
So, out here, one thing is that I found that the registry has made a slight mistake in the call this.
Okay.
It should be this
Versus this.
versus this. So this has to be rectified, and notices will have to be issued to the respondents.
My lord.
Okay. Now, you are appearing for who?
I'm appearing on behalf of Mr. M. Malhotra, my lord, standing counsel. He's
For?
appearing as a standing counsel for the Guwahati High Court, my lord.
Okay. But Guwahati High Court is not a party.
Aizawl bench, my lord.
No, he has been made an amicus curiae.
Has been made amicus curiae? Where?
Because there was an order from the Supreme Court. This you put and or amicus curiae.
Then the High Court should be made a party. Correct. In terms of the order dated 11/12/24 passed in WPC 304/2018 bracket Anand Arya versus Union of India with regard to conservation and protection of wetlands under the wetlands bracket conservation and management bracket close rules 2017. The state is to set up a state wetland authority. It is also seen in the documents on record that a Pala Ramsar site, RAMSAR, Pala, PALA, Pala Ramsar site has been identified in the state of Mizoram. Having an area of approximately 1850 hectares. Full stop. Issue notice to the state, to the respondents. Who is appearing? Mr. AG, you are appearing for whom?
1, 2, 3, and 5, my lord.
Mr. Samuel Vanshe Changte, additional AG appears for 1, 2, 3, and 5. For Ms. Zainab Sangpi, CGC appears for respondents number 6 and 7. What about State Wetland Authority? You can
I'll
appear.
accept a notice.
Okay, for 8 also, Mr.
Yes, ma'am.
Samuel. Then issue notice. Registry to issue notice to the respondent number 4 by registered post with AD within a week. List the matter after 4 weeks. The registry is also directed to make correction to the cause title by ensuring that the state respondents are made the respondents in the cause list. In the cause title.
For admission, item number 2.
As per the last court order, DMC was directed to file a detailed affidavit,
Yes.
and I have received the instruction this morning only.
Okay.
So if I may be given 3 days time
Okay.
to file
Okay.
the affidavit.
23, 24, 25. They were newly given.
And that notice issued to them.
The notice was issued to them on 14/2/2018.
14 2, so 1 month has not arrived. Right. Mr.
Zoram Chana.
Zoram Thana, the learned counsel for the AMC, submits that he has received instructions only this morning
Yes, my lord.
and he needs 3 days' time to file affidavit in terms of the last order dated 13/2/2025. The office note dated 6/3/2025 also states that there is no return of AD card or unserved notice from the respondents number 23,
My lord,
24, 20.
if I may
Okay.
interject. I have instructions to appear on behalf of the newly implemented respondent number
23 to
23, my lord. 23 only.
Okay.
I will be filing my power during the course of the day.
Okay, just say.
And I
indicate-
further seek 2 weeks' time to file my affidavit. my
Okay,
lord.
okay, just right. The office note dated 6/3/2025 indicates that there is no return of AD card from the respondents number 23, 24, 25. Full stop. However, Mr.
Sitlan Thiang Lima.
Sitlan Thiangnima submits that he will be appearing for the respondent number 23 and he will be filing his Vakalatnama
During the course of the day, my lord.
within the course of the day. He also seeks 2 weeks' time to file affidavit. Anything else?
My lord, I'm for respondent number 10 and 11.
Yes.
I've already filed my affidavit.
My lord, I'm appearing for the respondent number 9 as well, my lord. I have filed my affidavit, my lord.
Then no need, then it's okay. Mr. Elish Lian Shrima, learned senior counsel, appears for the respondent number
10 and 11.
10, 11 and files and submits that affidavit has been filed by him. Ms. Vani, you? Anything to do? No. Okay. Ms. Vani appears for the state government. Joseph, anything to say?
No,
Nothing.
not as of now, my lord.
Okay, right. List the matter after 2 weeks.
Obliged, my lord.
For hearing, item number 3.
na kaya dictation ka pencho wa.
My lord, this is a jail appeal. I'm appearing on as a MICAS for the appellant.
Okay,
And my lord, this is Indian PS case.
correct. So,
Yes. And the story of this case is that, my lord, on 10th of June 2018, at around 10 a.m., that is Sunday.
10 June 2018,
Yes, my
Ah.
lord. At around 10 a.m.,
10 a.m.
I got a phone call from Mrs. Nutei, who owns a goldsmith shop at New Market. And she requested me to deliver goods for her friend, Dalruat Pui. Dalruat Pui is the co-accused in this case, my lord.
Nute is not a co-accused.
Yes, my lord.
Nute is not a co-accused.
Yes. And on the next
Requested to deliver what? Parcel?
parcel, yes,
A parcel for who?
for her friend Dalruat Pui.
Lalruat
To
Pui.
someone else, yes.
Okay.
And on the next day, that is 11/6/2018,
Yes.
I went to the shop of Nutei,
Ah.
and after sitting there for a while, Mrs. Ruatpui came and she asked me to deliver the goods. And after that, I asked the details of the person to whom I was to deliver the goods. And she responded me saying that I have already given your number to them. Go near the high mass in the market area and you will get a call. So Mrs. Ruatpui did not tell me about the name, the exact person which I'm going to deliver the goods. And I went near the high mass with Miss Ruatpui parcel. And after a short while, someone who claimed to be the person to collect the parcel called me. And I informed the person that I'm already standing near the high mass. The high mass is within the Bazarpui area, my lord, New Market area. And the person who was to collect Miss Ruatpui's goods came and said, "Are you the person sent by Miss Ruatpui?" And I responded affirmative, and I hand over Mrs. Ruatpui parcel to him, to the person,
And you were caught.
and I'm in court. Yes,
And that person who collected it was the excise, police or what?
police, my lord. Yes, and my lord,
And how much did you get? How much money did you get for delivering the parcel?
I was not exactly known, my lord.
Huh?
I'm just acting as a delivery person, my lord.
No, delivery boy also gets money usually. Zomato, all these, they also get money.
I do not know how much he actually received, my lord, the money.
But he received.
Might be.
No,
It's not in the evidence at all, my lord.
oh, it's not in the evidence. Okay.
Oh, yes, yes.
There's nothing.
Yes.
So okay, no one gave evidence to that effect.
Yes. And facts which was not disputed is that and I was bringing the parcel which is in YY box. The parcel is YY box, and inside the parcel, I did not know there was illegal substance.
How much heroin?
4.98 grams.
4.494
494. Yes.
grams.
Yes. 494.98 grams.
494.98.
98. Yes.
That means 495 grams in a way. So nearly half a kg.
Yes, my lord. That is in the commercial quantity, my lord. Yes. And I was booked under 21C.
Ah.
Yes. And in
And
this,
both of you were convicted.
yes, my lord. Mrs. Ruatpui and me was convicted.
Did you have any defense witness?
Yes, I'm under 313 as well as I have given my own defense witness, my lord.
You gave your own defense.
Yes.
What about this Nute? She was not made a witness.
She was not made a witness and she was not questioned by the prosecution.
No,
at
no.
all.
Why didn't you make her your defense witness? Because your entire story starts from Nutei. Your entire story is that Nutei had called you. You had done it because you knew Nutei.
Yes, initially, yes, my lord.
So why didn't you use Nutei as a defense witness?
That I'm not sure, my lord. And from the prosecution side also, my lord, there was no evidence to show that I have mental state and I'm aware of the goods inside that parcel.
So you're using the latest judgment.
Not the latest, but the relevant judgment, my lord, which I found it necessary. And first
So
one
that
is, my
is your
lord,
entire story. That's
Yes,
all.
that is my
That-
entire
that-
story.
Nothing else.
yes,
So you're not challenging any procedure, nothing. Your basic case is that
yes,
you were sent by this Rotpui
yes,
to deliver and you got caught. And you were in Nutei's shop because Nutei had requested you to deliver on behalf of Rotpui.
Rotpui was also there on the next day, my lord.
Correct, but
Yes.
on the first day, 10th June,
Yes,
Rotpui did not call you, it was Nutei who called you.
yes, yes, my lord.
So everything started from Nutei,
Yes, my lord.
naturally. But
And-
where is Nutei's shop located?
New market area, my lord.
New Market area.
Yes.
And where did you have to deliver the consignment?
I went to, in the middle of the new market, that is.
That
there was
powerhouse?
Yes, no,
Power.
no,
And
high
what-
mass.
That is how many feet away from Nutei's shop?
That I'm not sure, my lord.
That is in that area only.
No,
Must be how many feet away? 50 feet away?
around maybe more than 50 feet also, my lord.
Maybe 50 feet. Okay. So that means even Rotpui could have gone and delivered.
But Rotpui did not come along with me. He was in Nutei's shop during that time.
And where do you live?
I live in Bethlehem, Veng.
And what do you work as? What work do you have? No work.
On daily bread earner, my lord.
Daily bread earner.
Yes.
So you went all the way from Bethlehem Wang to New Market to deliver a consignment
No,
just
no.
50 feet away or 100 feet away, whatever. Huh?
I used to work near market area as a daily laborer sometimes, my lord.
Because that high mass is in the market area only.
Yes, yes.
I used to go there marketing before they started construction. It's a vegetable market. Anyway, then anything else? That's all.
That's all, but my lord, I have citations in this regard, yes. Uh, 2017, 15 SCC, 684.
2017-15 SCC,
SCC 684.
paragraph
Paragraph number 9 and 10.
9 and 10. Yes,
Yes, my lord, may I read?
yes.
The presumption against the accused of culpability under section 35 and under 54 of the Act to explain possession satisfactorily are rebuttable. It does not dispense with the obligation of the prosecution to prove the charge beyond all reasonable doubt. The presumptive provision with reverse burden of proof does not sanction conviction on the basis of preponderance of probability. Section 35, Clause 2 provides that a fact can be said to have been proved if it is established beyond reasonable doubt and not on preponderance of probability. That the right of the accused to a fair trial could not be whittled down under the Act was considered in Noor Aga versus State of Punjab. An initial burden exists upon the prosecution, and only when it stands satisfied would the legal burden shift. Even then, the standard of proof required for the accused to prove his innocence is not as high as that of the prosecution. Whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond all reasonable doubt. but it is preponderance of probability on the accused. If the prosecution fails to prove the foundational facts so as to attract the rigors of Section 35 of the Act thus reads, which is possession of contraband by the accused cannot be said to have been established. And next is,
No, please carry on reading.
yes, my lord.
With a view to bring.
With a view to bring within its purview the requirements of Section 54 of the Act, elements of possession of the contraband was essential. So as to
Element
shift-
of possession of the contraband was essential.
so as to shift the burden on the
So
accused.
element of possession is there. You're yourself not denying that fact.
Yes, I was not denying that I bring the parcel.
Only thing you're saying is that you did not know the contents.
Yes, yes, I didn't know what was inside the parcel.
Ah.
The provision being exception to the general rule, the generality thereof would continue to be operative. Namely, the element of possession will have to be proved beyond reasonable
So you
doubt.
see, possession is there, constructive possession is there. The only thing is that your case is that you did not know what was the contents
Yes,
of the packet. But the fact that it was in your possession is not denied by you, it's admitted by you.
yes, yes. It's in my evidence also, my lord, that I bring the parcel, but in the cross-examination, my lord, it's there that, which is in page 15, it is a fact that I do not know the accused what we prior to this case.
So?
I deny the reason that I was with the accused what we near the high mass at the time of seizure and arrest. I deny the suggestion that when the police personnel
But
approached
you are
us.
not denying the fact that it was Lal Rotpu who gave you the parcel.
No, my lord, before the incident happened, I didn't know the road way before. I just met her at the New Market near Nute's shop. And in the 313, my lord, I already stated that 313 is in page 4, my lord.
Yes. Yes.
The question number 1. Evidence against you is that in the early part of May 2018, one unknown female person telephoned you, she thereby asking to search customer for selling heroin. You therefore searched customer and later found one intended customer. Do you have any explanation on it? It is false. They rather asked me to see customer, and they also promised me to give me a reward. As we were facing financial constraint at the time, I agreed the same. I also gave seized heroin to the intended customer, but I did not know that it was heroin. And question number 2 is, evidence against you further elicited that on dated 11/6/2018, you met your intended customer. You also confirmed that he have money to purchase, but not having enough money to purchase your all seized heroin. You therefore took heroin from your female partner when you were dealing heroin with your intended customer at New Market near High Mass, Dorpu Azol. The police force caught you red-handed with seized heroin. At that time, you carried a rucksack which contained heroin. Co-accused Srimati Lalwatpui also carried Rambo polythene which contained heroin, and the total was 39 soft cases of heroin. Do you have any explanation on it? It is true and correct, but I did not know that it was heroin, and I therefore did not have any consciousness on it. Evidence against you further elicited that the police personnel recovered and seized the seized heroin in the presence of civilian witness. Do you have any explanation on it? I did not know the presence of civilian witness. Prosecution evidence further reveals that weighing, packing, and sealing of article was done by the police personnel in the presence of reliable civilian witness. And question number 5 is FSL report, and 6 is, do you have any other explanation in your case? I am seriously regretted, and I never indulged with any illicit drugs and drinks. I did not have any consciousness on seized heroin. That is under 313, my lord.
Come to page 14. This is your evidence.
Yes, my lord. Number 7 is, my lord, in this case, the actual owner of the goods is Mrs. Ruatpui, and I'm just the delivery person. Mrs. Ruatpui's
But
goods.
don't you feel funny that you were asked to come to the shop only to deliver YY? How many packets of YY were inside?
One case, I'm not sure how many packets of YY is contained.
And who brought the YY packet? Ratpi brought it into the shop of
Yes,
Nutai or what?
Ruatpui.
Ratpi brought it into the shop.
Yes.
She carried it.
From my evidence, it was assuming that she was carrying the YY, but I have no further evidence. And in the judgment also, my lord, which is in page 21, the Mrs. Ruatpui, during the trial of the case, she was absconded.
What has happened to her? She's absconded now.
Yes, yes. Till date, she absconded. If you lost him, may kindly see page 21.
She's from Myanmar or from
Yes,
here?
from Myanmar.
Oh, Ratpi from Myanmar.
Yes, yes.
And Nutai, what happened? Nutai, they did not arrest.
Yes,
No.
no arrest.
What was your statement to the police at the initial registration of the case?
My statement was not enclosed, my lord, here. It was not in the paper book.
Yes. Anything else, by the way? Anything else?
Apart from this, my lord, no more.
Nothing.
Yes.
Yes, madam?
Yes, my lord. The prosecution has been able to prove that the accused is guilty of the offense. And moreover, the fact that the accused pleaded that he has no conscious possession cannot be admitted, my lord. The manner, the way he delivered the goods, that was also in the marketplace. So, my lord, the prosecution proved that he has conscious possession, and which is
Now
proof.
there is a recent judgment passed by the Supreme Court. Is there any recent judgment regarding the issue of conscious possession?
I have no idea at the moment, my lord.
Okay.
And my lord, during his examination under Section 313, even here he even admitted that he has indulged in this kind of business because of their financial difficulties. So, my lord, it is proof that he is having a conscious possession and he indulged himself in this kind of business due to their financial breakdown. So, my lord, the prosecution has proved their case beyond reasonable doubt, and the accused fails to prove himself the reverse burden provided section under 34 and 55 of NDPS Act, my lord. So, there is no reason to interfere in the judgment passed by the learned trial court and prays to dismiss the case, my lord. Even the evidence all prove that he had possessed the contraband articles, and the contraband article was seized from his possession, and he was caught red-handed while he
Any
was
citations in your favor?
not at the moment, my lord.
There should be ready with citations, this and that.
We see Your Lordship's indulgence in mentioning part 2, item number 1 and 4, Lordship.
Yes.
My Lord, I'm the newly appointed GA.
Huh?
I'm the newly appointed GA.
So,
So, my Lord, the file has been just endorsed to me recently. So, these two cases may come up after 3 weeks, my Lord.
1 and 4.
1 and 4, I have taken consent of the...
No, I've got to issue notice on this is a motion case. What is
Hearing
this?
is part 2, my Lord.
Part 2.
Oh, sorry, my Lord, part 2.
There is no part 2. There is a part 2. Oh yes, there is a part 2.
Hearing list.
Okay. Okay.
Item number 1
On
and
the
4, my
prayer
Lord.
for adjournment made by Mr.
Benjamin Lalthamwana.
Benjamin Lalthaman, learned GA. This is the matter after
3 weeks, my Lord.
3 weeks.
I seek your Lordship indulgence. My Lord, part 2, item number 5. If this may come up on Wednesday, I have taken the consent of...
Okay, okay.
My Lord, obliged.
Your Lordship, if I may seek indulgence on mentioning part 2, item number 3.
Ah,
As the main counsel, she went out of station last week and came back with a fever. Now she's in a sick bed.
okay.
If the
Who's this?
ordinance
Who's the council? Jacinta.
Yes, my Lordship.
All right. On the prayer for adjournment made on behalf of Ms. Jacinta Lothanmoy, learned counsel for the petitioner who is purportedly ill, lives the matter after
2 weeks.
2 weeks. He's going to be ill for 2 weeks.
Yes, Your Lordship. And I've
Are you
already
sure?
taken, yes, Your Lordship. And I've already taken consent from the other party also.
Yes, okay.
Obliged.
For motion, item number 1.
My Lord, in this matter, there are some minor typographical mistake in the cost list and the prayer portion. So, if I may be allowed to replace the page number, my Lord.
How many mistakes?
Page number 1, page number 2, and page number 19.
Has it been uploaded? Has it been uploaded? You see, because in the CIS system, a lot of mistakes.
No, my Lord, with regard to the letter number and the date only, my Lord. The letter number and the date have to be changed, my Lord.
Okay, all right. Heard Mr. C. Tlan Thiang de Malan, counsel for the petitioner, who prays that he may be allowed to change page number
1, 2, and 19.
1, 2, and 19 of the writ petition. The prayers allowed. The petitioner shall make necessary changes to the said pages with the registry within
2 days, my Lord.
2 days. That's all.
Obliged, my Lord.
Item number 2.
My Lord.
Here also.
No, my Lord, this is correct. In the first item, I had take the page number of this item number 2. My Lord, this is the second time the petitioners are before this honorable court, my Lord. There are the former employees of Mizoram KVI board, my Lord. And they are pensioners, my Lord. And while they were receiving pension under the 2002 Mizoram KVI board pension regulations 2002, my Lord. An amendment was made in the year 2019. So some changes were made in their entitlement of pension, my Lord. And subsequently, I had filed a writ petition challenging the amended regulations before the Honorable Division Bench of this court, my Lord. And the Honorable Division Bench held that the regulations amended regulations which were made in the year 2019 cannot have any retrospective effect upon the petitioners. So, my lord, this petition is filed for directing the respondents to give the petitioners their...
Who are the respondents?
Respondents 1 and 2 are the Mizoram KVI board, my lord. And 3 is the Commerce and Industries.
But whether the state can be fastened with the liabilities?
This, my lord, the KVI board is under the administrative...
But that issue will have to be decided, correct?
yes, my lord.
That issue will have to be decided. Was it decided by the division bench?
It wasn't decided, my lord. The Honorable Division Bench had only held that the amended regulations cannot have any retrospective effect upon the petitioners.
So that issue will have to be decided.
Yes, my
Right.
lord.
Heard Mr. C. Tlantiangli, my learned counsel for the petitioner, who submits that the petitioners are retired employees of the Mizoram Khadi and Village Industries Board. Correct?
My lord.
He submits that the petitioners were being given pension after the retirement. However, due to amendment of the Mizoram Khadi and Village Industries Board's Employees (pension) Regulations 2002, hereinafter referred to as the 2002 regulations, the petitioner's pension was stopped,
It was modified, my lord.
was modified,
Yes.
was modified, full stop. How? Modified? How?
Modified in the sense that there are some 3-4 modifications, and one modification is that after the death of the pensioner, the family pension will be
Okay, so that part, that family pension part.
yes, my lord.
Okay. Was modified to
Family
the
pension will be continued only for 12 months.
to the extent that after the death of the petitioner, after the death of the pensioner, the family pension would continue
Only for 12 months.
months. Family pension would be given, not continue, would be given for 12 months only. The same was put to challenge before the division bench of this court in WPC 10 of 2022. And 11 of 2022. WPC 10 of 22 and 11 of 22 were disposed of by judgment and order dated 6/10/2023 by holding that the amendment made to the 2019 regulations could not have any retrospective effect. Full stop. However, full stop. Further, the division bench also held that the issue as to whether the state could be fastened with the financial liability of the KVIB had not been decided in WPC 10 of 22 and 11 of 22. Full stop. Next, the petitioner's counsel submits that despite the division bench judgment, the pension has not been given to the petitioners
As per the 2002 regulations.
as per the 2002 regulations. 2019, 2002 regulations. Issue notice, returnable in 4 weeks. Who accepts? Where's the government? Or where's the government? Miss Caroline Lungoypui accepts notice on behalf point number 3. Petitioner will take steps for service of notice upon the respondents number 1 and 2 by registered post with AD within 3 days. This is the matter after 4 weeks.
Oblige.
Item number 3.
My lord, I have been requested by the learned counsel that she is on legs, and if this matter...
Item 3.
Yes, my lord. Miss Valentina,
Okay, we'll wait for her.
my lord.
Yes, next.
Item 4.
Yes, what is your case?
My lord, the case basically is that the land of the instant respondent number 1, which is a VC pass, was acquired for construction of...
This is an arbitration case, arbitration
Yes.
appeal.
Yes, my lord.
Acha.
My lord.
Your land was acquired.
Land of the respondent number 1. That is a VC pass. That was acquired for construction of and widening of Dulte to Champhai Road in National Highway 06. And there were 3 surveys, assessments were made. The first one was on 16 March 2021. Survey was conducted by one Mr.
16 March 21.
Yes. That was conducted by one Mr. Ardia. Only the full name has not been reflected. It only says...
Dulte to Champhai.
Yes, my lord.
Then?
And in that assessment sheet, the instant respondent number 1 did not affix his signature. And second assessment was made on 23rd.
Who is respondent number 1?
This is the VC pass holder, my lord.
Respondent number 1 is VC pass holder?
My lord.
Respondent number 1 is Kalian Lira.
Yes, Kalian Hira. He is the holder of the VC
Acha,
pass.
holder of the VC.
Yes.
He did not affix his signature?
Yes, in the assessment that was made by the surveyor, while his land was assessed.
Okay, okay. In the assessment order?
Yes, in the assessment sheet.
Sheet.
Yes. And second assessment was made on 23rd March 2021. And in that,
23rd March 21, yes.
yes, and in that assessment sheet, his signature was affixed. He had subscribed his signature.
Who's the
Respondent number 1.
Uh-huh.
So, when the compensation release order was issued by the instant respondent number 2 on 22/09/2021.
22?
09/2021.
Yes.
The compensation was made according to the 23rd March 2021 assessment.
Okay.
And the assessment that was made on 11/03/2021 was not included.
11/03/21 was not included.
Yes. And he has made filed an application before Kala. And accordingly, reassessment,
Was ordered.
final reassessment was made on 14/10/2021.
14/3/21.
14/10, my lord.
14/10/21.
2021. And then he had applied for payment of compensation as per this assessment. And that was presented before the arbitrator. And the arbitrator has passed an order. This is at page annexure number 2, page number 38. And the operative portion is, my lord, at page number 47 to 48, with the final amount of rupees 68 lakhs, 26,353.
How much?
Page number 42. Even though the...
42?
Yes, page number 42 is the cost title of the order. And operative portion is at... I apologize, my lord. Page number 38 is cost title of the order, arbitration order. And page number 47 and 48 are the relevant paragraphs where the amount has been recorded.
How much is the amount?
Total amount is 68 lakhs, 26,353.
Then?
Arbitral order at page number 42, my lord. Page number 42. If your lordship could kindly come to paragraph number 5,
yes.
Last line.
Yes.
Last line, if I may read. Representatives of NHIDCL also not object the claim. This was reflected.
What?
Even though we are present. And my
What?
lord,
Object the claim? Where? Where?
at page
Kala
number
has no objection on the grievance.
yes, my lord.
On the grievance of the authorized representative of the applicant. Who is the applicant? The respondent.
Yes. So this was reflected that the instant appellant had no objection to the.
The instant appellant
Yes.
out here? No.
The instant appellant here in is NHIDCL, my lord.
Para 5 says Kala has no objection on the grievance of the authorized representative of the applicant.
My lord.
Who is the applicant?
The applicant therein was the instant respondent number 1.
Say, that's what I'm saying. So,
Yes, my lord.
so he is the respondent.
Yes.
Then?
And at the last line, representatives of NHIDCL also not object the complaint. So accordingly, this award was passed. And being aggrieved, my lord, I have the instant appellant had filed an arbitration petition before the learned district and sessions judge in Champhai. However, that my petition was dismissed by the impugned order, my lord, stating that since I did not have any objection to the application filed by the instant respondent herein, that the same cannot be maintained.
You see one thing,
My
you
lord.
see, an appeal can be filed only under section 34. Have you filed, where is your appeal petition?
My lord, I have filed under section 37.
34 is the first appeal, 37 is here.
My lord,
So you see, arbitrators' award can only be challenged in the first instance under section 34.
my lord.
So you went before the district
My
judge
lord.
under section 34, correct?
Yes, yes. Section 34 is at annexure number 3, page 50,
Page 50.
my lord. Page 50. This is the cost
Now-
item. Yes,
Section 34
yes.
provides for, I think, 6 instances under which an arbitration
lord.
award can be set aside.
My lord.
Do you fulfill any, does your case come within the 4 corners of any of those 6 conditions laid down?
My lord.
Which one?
Uh,
Let us see the Arbitration Act.
if,
Yes,
if I may read.
yes,
Section 34, application for setting aside arbitral award.
yes.
Number 1, recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. Subsection 2. An arbitral award may be set aside by the court only if the party making the application establishes on the basis of the record of the arbitral tribunal that, number 1, a party was under some incapacity. Number 2,
So you are not under any incapacity.
My
Number
lord.
2,
Number 2, the arbitration agreement is not valid under the law to which the parties have subjected to it, or failing any indication thereon under the law for the time being enforced.
so this also is not
No.
attracted
No, my
then?
lord. Number 3, the party making the application was not given proper notice of the appointment of an arbitrator.
So
or the
this also is not
My lord.
attracted?
Yes. The arbitral award deals with the dispute not contemplated by or not falling within the terms of submission to arbitration. Now this comes, my lord.
How does it come?
Because, my lord, I have...
The arbitration award deals with a dispute
Yes.
not completed or not falling within the terms of submission to arbitration. You have both admitted to the arbitrator that this issue has to be decided by
My
him.
lord, in this regard, my lord, I have annexed copy of the WhatsApp conversation that has been held between the...
No. Those WhatsApp conversations cannot be used.
My lord, the fact that I have submitted, I have made an objection. However, that fact was not
No,
recorded.
you see,
my lord.
the arbitral award deals with a dispute not contemplated. Now, what was the dispute between the parties?
My lord, my contemplation was that the arbitrator could not have relied on the assessment, sole assessment, without without adducing evidence, my lord. Evidence were not adduced during the arbitral proceedings. And I have also made an objection.
but you see,
However,
that
my
is-
objection was not recorded, my lord.
You see, that is not the issue. You see, the issue is in 34.4 says
lord.
that if the arbitral award deals with a dispute not contemplated or not falling within the terms of submission to arbitration.
My lord.
Now, this does not talk about whether the arbitrator did it wrong or did it right. It just says whether the dispute was a contemplated dispute. It was a contemplated dispute. You are worried about you should be getting under this assessment or that assessment. So the assessment is not the issue. It's only the amount that is the issue. So this is a dispute that falls within the issue to be contemplated by the arbitrator. So what is wrong? So this also, your case doesn't come under this also. You see, you cannot act under 34 or 37. This court cannot act as an appellate authority looking at the merits, or it cannot reappreciate evidence as to whether this should have been done or that should have been done.
My lord.
And the Supreme Court judgment now says that the appellate authority cannot modify an award. Now you want to modify the award.
Or, my lord, if the matter may also be remanded, my lord, for taking evidence, my lord.
You've got to first come under
Yes, my
Section
lord.
34. Otherwise, how can you do it?
My lord, my case is that I am covered by this subsection number 4, my lord.
I don't think so.
Or if I may continue, my lord, just
Yes.
reading. Number 4, Roman 4. The arbitral award deals with the dispute not contemplated by or not falling within the terms of the submission of the
So it comes within the
Or-
terms of submission. It comes.
Here.
Yeah, the issue is with regard to assessment.
Yes. And the second part, my lord.
Huh?
Second part.
Yes.
Or it contains decision on matters beyond,
Beyond the scope of
the
arbitration.
submission to arbitration.
Yes. So what was the
I-
scope?
My submission was not recorded, my lord.
That is not what it means, Mr. Counsel. That is not, your submission was recorded or not is not the issue. It is not like a trial court.
My lord.
The issue is, there is a reference made to the arbitrator. If the issue to be decided comes within that reference, whether the arbitrator has done it rightly or wrongly is not an issue, unless it is perverse. The issue is whether the issue that has been referred has been decided or not. Or, now this 4 will come only when an issue which is not contemplated to be decided by the arbitrator has been decided.
My lord.
So how does your case come in?
My lord, if I may take your lordship to...
What does the first appellate court say?
my lord,
With regard
since I did not make any objection in the first arbitral proceedings, so I am not...
Objection to what?
to the submission of the instant respondent hearing, respondent number 1.
Mr. Counsel,
My-
can you
this
give
is
me
a-
some citations? You see, there are so many citations on arbitration.
This is at page number...
We cannot act as, we are an appellate authority, but we cannot go and reappreciate evidence to such an extent as to... So the compensation is to be given to him under Section 6, under the final assessment,
my lord,
or under the second assessment or the first assessment. Which one?
my lord, on the third assessment, however, that has to be proved by evidence.
It is a public document. It is. Why does it have to be proved? What do you mean?
My lord, no evidence.
Assessment is not to be made by you. You are not the authority. Who says that you have got to take the permission of the authority
My
to
lord,
make an assessment of how much is to be paid? I mean, of the individual.
my lord, even though I have no judgments with me today, but there are judgments that contents of a document has to be proved, my lord,
No. Please look at.
by evidence, my lord.
You see, Mr. Counsel, this is for compensation.
Yes.
Assessment is made by whom? Assessment
Yes.
is to be made by whom?
My lord, assessment was made by Kala.
Not by the landowner.
No.
Then, if it's made by the Kala, then what is wrong? When they have said that they have made it, what is wrong? Is it their case that they have not made it? You cannot just object for the sake of objecting. Or am I not getting your case? I don't know. You tell me.
And also, my lord, here in the same section 34, my lord, if I may read to clause B, sub number 2.
Yes.
The court finds that the arbitral award is in conflict with the public policy of India.
Correct.
With this-
Show me
with
the
this-
public policy
With
of
this
India.
respect, my lord, page number 67, annex of 4. And annex of 5, my lord.
Yes.
I will read, first I will read the Annex 5, page number 68.
Yes.
To the so-and-so subject, so-and-so case. Sir, I am directed to refer to your letter number so-and-so, dated so-and-so, on the subject cited above, and to authorize NICDCL to defend the above case on behalf of MORTH before the Court of Honorable District so-and-so, and safeguard the interests of MORTH in the matter. Further, it is reiterated that it is implied from the MORTH letter dated that NHIDCL has already been authorized to defend and protect the interests of MORTH in all courts cases pertaining to its mandate.
How does it so?
So, my lord, accordingly, my lord, I have defended my case. However, my submission was not recorded.
Submission, that is, sorry. That's all. The submission not recorded. That's all. That's the entire case.
My lord.
So let me get this straight. As far as I can make out, your case is that your land was acquired for construction of a road, and a survey was made on 11th March, and then another was made on 23rd March.
16 March, my lord.
Huh?
First
16 March.
Yes, first on 16.
And the second one made on 23rd March.
Yes,
And the third one was made on 14/10/21.
my lord.
So those assessments have been made. So what is wrong with the assessment made?
My lord, even though I have objected, I have made my objection
Objection
But-
to the amount.
to the application filed by the instant respondent hearing. But my obligation.
State respondents? What state
Respondent number 1. Respondent number 1.
Respondent number 1 is the private
Yes,
person. He's
yes.
not the state.
Yes, my lord.
Then, so he's made so why?
However, my objection was not recorded, and it was not only not recorded, but
No,
it says
just tell me
that I have
something.
no objection, my lord.
This final assessment was made on the basis of the decision made by Kala, is it?
This final assessment was made, yes, my lord. However,
No.
only one surveyor, Mr. Ardia.
Huh?
Only one surveyor, Mr. Ardia, my lord.
Only one surveyor was did
Yes.
the survey.
Yes.
So how many surveyors should go according to you? No. You went for arbitration and challenging what? What did you
My lord,
challenge?
since I am an affected, I'm an affected party. In the, it is my humble understanding that I should be present during the assessment, my lord.
Who says? Who said? And what is the law?
My
Why?
lord, as per various directions of this court, my lord, when
No. That we give directions. That is not.
lord.
It's not required. You see, in India, say when there is a highway made from Delhi to Agra or Bombay to Gujarat, you're going to lakhs of people are going to be there. It's not possible.
my lord,
No,
at least
it's not
the-
possible. It's not done. That's not the way it's done.
at least representatives are.
They can submit, you can make a representation, that's all. Then beyond that, what is there? No, why did you go to Kala in the first place? What was your grievance?
My
You were aggrieved with which survey, with which assessment?
My lord, there is a judgment that's.
Just answer the question.
My lord,
There are 3 assessments made.
yes.
Now, you are aggrieved with which assessment?
Final assessment, my lord.
Why?
My lord, because.
You were not there.
Yes.
Because you were not there.
Neither my representatives, my lord.
And
And-
so then you challenge this 3rd assessment before Kala?
My lord. And there is also. Not only I was not represented, however, and also my objections were not recorded, my lord.
Did you write a letter to them? You see, Mr. Counsel, you went to Kala against the 3rd assessment or not?
No, my lord. Because that after final assessment was made, the instant respondent number 1, private landowner, he has filed the arbitration proceeding, my lord.
Okay, so he went
Yes,
for arbitration.
yes.
He was aggrieved with what?
due to non-payment, my lord.
Due to non-payment.
Yes.
So,
And I have filed my objection. I have submitted my objection, but that was not recorded.
so did you file any application for under that provision for going to an arbitrator challenging this final assessment?
Other than that, no, my lord.
Then,
Other than
then
the,
where is your case?
Section 34 application.
When-
Other than that, no, my lord.
No, section 34. I'm not
Yes.
on section 34. Where is the provision for arbitration? In this kala, where is the provision?
My lord, I have not annexed.
Where is your case? That means you are not aggrieved with the final assessment. If you are not, if your protest was not recorded, or you were not made a party, you should have gone to Kala for arbitration under the provision yourself. You did not go. You have missed the bus.
No, my lord.
Then
Yes.
what now? What was the reference made to the arbitrator? What was he to decide? Did it go through the High Court or how did it go?
No,
How did he went directly?
Yes.
Now where is his letter asking for arbitration?
This is at page number 31.
So he has gone to Kala, to this arbitrator, under what provision?
My lord, provision is not recorded, my lord.
It will be there. Where is it? Under what? Under the National Highways Act or what?
In the last paragraph, my lord, according to the 2013 Land Acquisition Act.
There is no Kala there, is there? There is a Kala there. Okay, so he has gone under Kala there. So now he is gone and challenged this. Out here there is no 23rd March. There is, okay. To continue the remaining assessment is not a second assessment. You
Because
page
the
31.
first, yes, my lord, first assessment, his signature was not, signature. of the
Anyway,
single
so
member.
at the end of the day, the 14th assessment was there. The 14th October was there.
Yes.
Then
And my lord, this is not the only case wherein the arbitrator had recorded that the instant appellant has no objection. In fact, my lord, I have annexed some other cases from
who has no objection?
that the instant appellant. In
The
similarly,
instant appellant is you.
yes, my lord. In
You have no objection to what?
in similarly situated cases.
No,
my
no,
lord.
please, you don't go jump from one thing to another.
My lord.
The issue is, you have no objection to what?
To the application filed by the instant respondent number 1 before the arbitrator.
Then,
That
the
same has been,
applicant, who's the applicant? Who do you mean is the applicant? You mean the respondent?
yes,
Say respondent, don't say applicant.
my lord.
You're jumbling up, you're confusing the court.
Apologize, my lord.
Now you see, the assessment was made
Yes.
on October 21. Now this assessment, you have not challenged it.
No, my lord.
He wants, that respondent wants it to be implemented.
Yes.
Correct. And the arbitrator has taken a decision that it should be implemented.
My lord.
Where is that?
This is from page number 47.
Page 47. Till where is the end?
End is 48, my lord.
So now, what was the assessment made in the 14 October 21? What is the assessment made? How much was the assessment?
My lord, this is reflected from page number 43. 43. Paragraph number 7.1. Assessment of crops and trees totaling.
No, this is again the order. Where is the as per the assessment made on 14 October 2021?
Other than this, my lord, there is no assessment order, my lord.
Mr. Counsel, this page 43
Yes.
talks about action taken report on the interim order.
Yes.
White letter number 17 January 2024.
My lord, my lord. However, other than this, my lord, there are no.
But you were just talking about 14 October 2021, the final assessment.
Yes.
Where is that final assessment?
I have mentioned that because the incident respondent number 1 herein had made that in his application, my lord.
I'm not getting. You see, you're not clear of your case. You see, it's no point putting a thick case file without understanding your case.
My lord, my case is that.
Okay, just tell me one thing.
Yes.
In the first assessment order, what was the amount? Whether you signed or not, that is not the issue. What was the amount assessed for you?
It's not written, my lord.
Not written.
It's not.
Okay, in the second assessment amount of
Yes.
23 March 2021, what is the assessed amount? Where you had given your signature.
My lord, these assessments are mentioned by the incident respondent. However, the amount has not been given, my lord. The amount has not been mentioned.
By the respondent?
by the
How can the
respondent.
respondent be? Assessment is made by the surveyor, not by the respondent.
Yes, my lord.
Then, supposing the government is going to acquire my
Yes.
land,
Yes.
will I make the survey report?
And-
Will I make the assessment?
And even that assessment report
No,
has not
you think about it. I will list it again. List the matter on Wednesday. Think about it. You're not making sense.
my lord.
Please try to.
Item
otherwise
number
I'll have
5.
to dismiss it. You'll have, please, I'm giving you a chance. Yes.
My lord, in this IA, we are asking for a small correction in the course title, my lord. The name of the respondent has been,
Actually, you see, it is a criminal case.
it's a criminal case.
In a criminal case, we don't say represented by. Nowhere. We say what we usually do is, number one, state. State of Assam, state of Mizoram, state of whatever. NCT of Delhi, whatever. No representative.
Yes.
Number two, you make that person a party. That is the proper way. This is not the proper way.
So no, my lord, what has happened? In
I
the
know, I saw
original-
the order. That's
in,
not
in the
correct.
criminal complaint also. my
Huh?
lord. The original criminal complaint also was like that.
It is not correct.
Yes.
The Union of India, even as per the CPC or the state government, even as per the CPC, can only be represented by the secretary,
Correct.
not by some drugs inspector or something like that. And especially in a criminal case, there is no question of representation because it is a crime against society. It is basically the state. That's all. So what we usually do, say in POXO cases, you'll know, or in any other criminal cases in DPS. So and so versus the state of Mizoram or whoever, state of Manipur or whatever. Number two, the concerned officer.
Correct.
Or number three, not state of or Union of India represented by drug inspector. Cannot be. It's correct, incorrect. You see, like in criminal cases, the IO will be at number two
Yes.
or something like that.
Yes. Yes. No, lordship is correct.
So this actually, I think you have to make correction. Otherwise, I don't know. You can do it like this, but then
But my lord, even I was confused because we are challenging the original complaint and the order. So in that itself it was incorrect. So I'm not sure if we can make the correction at this stage, my lord. That is the difficulty I'm facing.
no. Actually, you see, because that is there.
In fact, this was we had this discussion in the last hearing also. It came up for motion.
This is not correct. I don't find any wrong, because if you can make it state and then number 2, but then this is not correct. Anyway, because what they are doing is again wrong. It's not. How can he represent he can represent, but in a different in his own individual capacity, not state is state.
My lord, the council is there online, my lord.
Yes, Mr. Mehdi, you are mute. Please unmute yourself. Cannot hear you. Yes? Cannot hear you. I cannot hear you. I cannot hear you, Mr. Mehdi. I cannot hear you.
Yes, but there is problem here.
What to do? Cannot hear you. Well, yeah, they should have objected in the trial court itself. Where is the Union of India representative? It cannot be Union of India. It has to be state. If it's a criminal case, not Union of India.
Or it can be the person only, my lord. I think there is a
No.
notification.
No.
My lord, I think there is some notification.
If it is a complaint, maybe. But
It's a
then
complaint, it's a complaint.
Maybe, but then again, it's a complaint made by the state.
Correct.
Made by that person, but it's on behalf of the state.
Correct.
It's a criminal case. Criminal case, always state is there. It is wrong. Very wrong. Anyway, we'll allow it. Let's see what happens. Since this court has already passed an order to that effect earlier. Right. Heard Mr. Joseph Weldensley, learned counsel for the applicants, and Mr. S.K. Mehdi, learned counsel for the
CGC.
The prayer of the applicants for correction of the cause title is allowed. The I is accordingly allowed and disposed. No, before that you write, the applicant shall submit a corrected cause title before the registry within
2 days, my lord.
2 days. The I is accordingly allowed and disposed of. Then you write in the main case, in view of the order dated today, 10/3/2025, passed in I criminal number 8 of 2025, the cause title is allowed to be amended as follows. Allowed to be corrected as follows. Take it. Then what is to be done? What is the case? What is your case here?
So, my lord, the case is, my lord, on 10/11/2021.
Now, where is the case? What has happened? You are challenging what?
I am challenging this order, my lord, of the Judicial Magistrate First Class.
On what ground?
So let me give you, lordship, the very basic facts. My lord, on 10/11/2021,
My lord,
a statutory drawing of samples of drugs was done in Mizoram government pharmacies, my lord. And one drug called Primaquine
Statutory drawing of
drugs under Drugs and Cosmetics Act. So what they do is, my lord, they draw drugs and they test if they are of standard quality. So certain drugs were taken, samples were taken, and they were tested, my lord. They were drawn on 10/11/2021. And these drug samples, my lord, were sent for testing on 12/11/2021 by the drug inspector to the government analyst. So the government analyst is the statutory authority who tests.
then
Now, my lord, the results of the drug samples came back on 28/4/2022. And according to this result, it was shown that the drugs were not of standard quality. So based on this report, my lord, the criminal complaint was filed. Now, my lord, in this case, basically our first ground of challenge is the report itself, my lord. The reason why we are saying this, my lord, because as per rule number 45 of the Drugs and Cosmetics Rules, 1945, it says that when a drug has been sent for testing to the analyst,
Mr. Kaur, can you challenge a report which is still in the investigation stage?
no, it's not in, my lord, a criminal complaint has been filed based on that report.
No. Criminal complaint might have been filed.
Yes.
Do you know when the period between investigation and the period between trial?
This one I don't know, my lord.
There is a judgment passed by the division bench of our court also that investigation will continue till consideration of charge, till charge has been framed.
In this case, my lord, process was issued.
No, whatever.
Yes.
Has charge been framed?
Charge has not
Then I'll give you that judgment. Where is that? I'll have to find out. Tomorrow I can bring it. In
Anyway,
fact,
my
it
lord,
was,
yes.
it was,
If-
huh?
My lord, if that is the case, my lord, then we'll draw. That is not a problem. But my lord, if your lordship will only hear this out, my lord. The first draft.
No. Why should I hear it out when that is the issue? Why should I waste your time and my time? I understand what you're trying to get at. Maybe you're trying to go into the merits of the case. But the High Court and the Supreme Court, I mean the High Court at least, and the other courts, we don't have the power to interfere at the
Because
time of the
my-
investigation.
Yes, the reason why we have come, my lord, is because we are relying on one Supreme Court judgment. Now, this Supreme Court judgment also, the court intervened, my lord, the Supreme Court, because process was issued. So,
Process was issued.
Yes, only because of this reason we have come, my lord. And I'm not sure of this charge frame and all of these things, my lord. That your lordship can. I will also check, my lord. But on that, because of that reason, we have come to this court, my lord. But I have the case here, but I have not provided the citation, my lord. We can have hearing tomorrow or day after tomorrow also, my lord.
What, with regard to, so this, show me the Drugs and Cosmetics Act. Yeah. No. Drugs and Cosmetics Act. That's the narcotics. No, but then this is the preliminary finding. You can only challenge it in the trial. How does it matter?
The charge has not been framed. That much I agree, my lord.
Then,
This was in Lalan Kumar Singh and others, my lord. Lalan Kumar Singh and others was the state of Maharashtra.
'27. Why don't I find this 27D What?
No, because my lord, that was wrongly written. It's supposed to be 27 small d.
Small?
Small d. They had mentioned 27 capital
Ah,
D.
yes.
It's small d.
Show me the Supreme Court judgment that you're lying.
My lord, Lalan Kumar Singh, I have one extra copy.
Yes.
My lord, at this stage, let me only show you. My lord, I think this is a very rough, wrong copy which I have, but if for today, my lord, it will be paragraph number 41, my lord. The conclusion. There only it says, my lord, the process has been set aside. Paragraph number 41, my lord.
Yes.
In the result, the appeal is allowed. The impugned order of issuance of process dated 30th March 2009, passed by the learned Chief Judicial Magistrate, Beat, and the order passed by the learned Session Judge, Beat, dated 25 so-and-so, dismissing the criminal revision, being criminal revision petition number 1 so-and-so, are quashed and set aside. So, my lord, the court intervened at that stage. So,
But out here there is a finding that the samples are not of the standard quality.
no, there are two grounds, my lord. We are challenging this on two grounds.
One is standard quality, first then.
First is, my lord, this report, as per rule number 45, my lord, of the drugs and cosmetics rules, the report has to be returned within a period of 6 weeks. In this case, my lord, it has been returned after more than 5 months. So that is the first ground of challenge, my lord. And second, my lord, this Lalan Kumar Singh, my lord, lays down a law which says that directors should not be punished simply because they are directors. The complaint has to specifically state, my lord, how the directors are involved in the day-to-day activities.
So that will depend upon the charge sheet to be filed.
No, it says in the criminal complaint, it has to be pleaded as to how they are, in the criminal complaint has to be pleaded how they are involved, my lord. In our case also, my lord, it has not been mentioned how they are involved. They have simply stated that these are directors. Perhaps, my lord, with respect to the first applicant and the applicant number 7 and 8.
Okay, anyway, right. We'll see tomorrow.
Yes.
Heard Mr. Joseph Elden, learned counsel for the appellant, who submits that the order dated 2/6/23, passed by the court of the JMFC Aizawl in criminal complaint 119 of 2023.
Yeah, pleasure, Lordship.
By which?
My lord, I have not received the copy, my lord.
You have not received a copy, okay.
Yes, my lord. My first time appeared before this honorable court, my lord.
First appearance, my lord, today.
First appearance, but I come to know there is.
No, because notice has not been issued at all, my lord. Notice has not been issued.
Okay. No, so what?
No, he
so
was
what?
my
So
lord,
what? Supposing you file a writ petition.
He was not here on the last occasion.
My lord, no, yes, on particular day my one case was listed, I was there, my lord. I request him to serve a copy, my lord. And I will appear, my lord, but he does not serve, my lord.
Okay.
He did not appear in court, my lord.
Outside the court, I request him, my lord, to serve a copy, my lord.
So when do you want the case to be fixed?
My lord, the day after tomorrow, if my copy is sent today itself by through email or.
Send it by today, by scan copy. Okay, right.
Day after tomorrow, day after tomorrow.
Okay, wait. What have I said? By which cognizance of an offence under section 27 bracket small e of the Drugs and Cosmetics Act, 1940 has been taken against the appellants. The case of the petitioners is that, the case of the appellants is that
Applicant.
some drugs were seized, were drawn from the appellant shop, is it? Appellant shop?
From Central Medical Store,
From the Central Medical Store, Izol.
Izol.
Manufactured by the appellants. Allegedly manufactured by the appellants. Naturally.
Manufactured by Algen Health. My lord, I'm not appearing for Algen Healthcare Limited. That is the accused number one.
Then
Algen
who are
Healthcare.
you?
I am the directors, my lord.
You're the
alleged-
director of Algen.
Yes, directors of Algen.
And you're the company. What else do you want?
They are the board of directors.
No, my lord. The company.
They are the board of directors. All of the directors of the.
Board of directors is the company.
No, they are not
Yes,
saying we are
yes.
the board of. Okay, my lord, they are. The company is different, my lord. It has a. My lord knows. very-
Mister, a company might be different, but a company is run by a board of directors. They are the trustees of the company.
No, but my lord.
Under the Companies Act, they are the trustees of the company.
Correct.
Then?
But my lord, they are not the company, my lord. I mean,
I cannot put the company to prison. I can only put the directors.
yes. Okay, but let's-
Anyway, right. You go, what have I said? By MS Algen Healthcare Limited, ALGN, Healthcare Limited. Because the petitioners are the directors of MS Algen Healthcare Limited. The samples were drawn, the medicine samples were drawn on 10/11/2021 and sent for testing. The report was issued on 28/4/2022, showing that the medicines sent for the medicines were not of standard quality. So, next para. The petitioner's challenge to the impugned order is on the ground that the report on the samples sent should have been made within
6 weeks.
6 weeks in terms of
Rule 45 of the
Rule 45 of the
Drugs and Cosmetic Rules,
Drugs and Cosmetic Rules
1945,
1945
as amended in 2017.
as amended in 2017. He further submits that, what is the second ground?
The directors, my lord, they have their role as to how they are involved in the manufacture has not
He
been.
further submits that there is nothing to show as to how. There is nothing to show in the complaint made by the respondent as to how the directors of the company were involved in the manufacture of the said drug. Mr. S.K. Medi, Leonard CGC, submits that he has not received a copy of the appeal of the criminal petition.
Criminal petition.
Under what?
482, my lord. It's a 482. Now it has become 528 of BNSS, my lord. Inherent powers.
Okay, don't have a petitioner, he submits that has not received a copy of the petition which has been filed under section
528.
Huh?
528 of BNSS.
528 of the BNSS
Correct, my lord.
on the prayer of the CGC. List the matter on Wednesday.
My lord, in the meantime, if I may be allowed to submit one additional affidavit, my lord, there are some records of the original complaint, my lord, which I only
You
received.
can submit, no, not an issue.
File your petition.
My lord, item number 3 is here.
Oh,
my lord.
3, okay, come 3. Yes, what is your case, madam?
Yes, may it please your lordship, my case is a covered matter, my lord, covered by several other judgments and orders. Our case is that we are staff nurses working under the government of Mizoram.
Yes, madam, we say covered matter. Shall we ask the authorities to consider the case of the petitioners, and if they find that they are covered, then it
Yes,
be
my
allowed,
lord.
that's all. Heard, miss?
Valentina Dinpui.
Valentina so-and-so, learned counsel for the petitioners, who submits that the petitioners are staff nurse, are working as staff nurse under the Mizoram Home Guards. Correct or no?
No, my lord.
Under the police department and the Mizoram Home Guards. Full stop. All the petitioners are now working as ward superintendent at Zoram Medical College, Falcon. Full stop. The petitioners' counsel submits that in terms of the office memorandum dated 15/1/2010, issued by the Government of India, Ministry of Health and Family Welfare, additional increments can be given to the petitioners.
Yes,
Why?
my lord. Because they have already achieved additional qualification at the time of entry.
Because they had
as
already
staff nurse.
achieved additional qualifications at the time of entry into service.
As staff nurse only.
As staff nurse. Full stop. She submits that the present case is covered by the decision of this court in WPC 42 of 2024, bracket Lalming Sani Silo and 52 others, versus State of Mizoram and 3 others. And as such has prayed for a direction to be issued to the respondents to examine and verify the claim of the petitioners herein and to grant them increments in terms of the OM dated 15/1/2020 and FR 27 bracket 10. Correct?
Yes, my lord.
Yes, sir. The learned counsel for the petitioners submits that that's all. Next para. The Mrs. Caroline Lungwaipui, learned counsel for the state government, submits that she does not have any, she submits that the respondent authorities may be allowed to examine the claim of the petitioners in the light of FR 27 bracket 10, the OM dated 15/1/2010 and the order dated 8/8/2024 passed in WPC 42 of 2024 to ascertain whether the petitioners are entitled to the grant of additional increments. First up, on considering, next para, Ms. Teresa Senso, her counsel for the petition, submits that she does not have any objection to the proposal made by the learned GA. First up. Next.
Valentina, Miss Valentina.
Very Valentina. On considering next para, in view of the consent of the parties, the respondent authorities are directed to examine the claim of the petitioners in the light of FR 27 bracket 10, OM dated 15/1/2010 and the order dated 8/8/2024 passed in WPC 42/2024 as to whether the petitioners are entitled to the grant of additional increments. The entire process, first up, thereafter, if the petitioners are entitled to the grant of additional increments, the same should be provided to them. The entire process should be concluded within a period of
3 months.
3 months from the date of receipt of a certified copy of this order. The writ petitions accordingly disposed of.
Much obliged, my lord.